on our Thursday weekly webinar. Today we are joined by two attorneys from Disability Rights Michigan, formerly Michigan Protection and Advocacy Services, and they are going to talk with us about advocating in this return to school environment of the pandemic. So just a few things about today's webinar. As always, it is being recorded and will be housed on our website of our partners, Michigan Developmental Disabilities Institute. And in this webinar format, all the microphones will be muted. If you would like to ask a question, you'll need to either use the Q&A box, the chat, or the hand raise function. You can access the hand raise function by going to the participant, by clicking on the participant button in your meeting bar, and there's a little blue hand, and if you click that blue hand, it'll show up for us and we'll be able to recognize you and allow you to unmute to ask your question. Unfortunately, today, we are not able to live stream on Facebook. And so if you know of people that were planning on watching via Facebook, please get in touch with them and ask them to join the webinar via Zoom today. And as always, closed captioning is available for those that would like to utilize that. And you access that by clicking on the closed caption button and selecting show subtitles. And again, thank you for joining us. I don't want to stay too long with my introduction. I would like to go ahead and turn it over to Aaron Diaz and Mitchell Sycon from Disability Rights Michigan. They've got a lot of good information and resources to share with us today.
Perfect. Thank you so much, Chedra, for that introduction. Mitchell and I are here today from Disability Rights Michigan to talk to you all about returning to school in fall 2020 in this unprecedented time. We are from Disability Rights Michigan. As Chedra said, we just recently changed our name from Michigan Protection and Advocacy Service. And we have a lot to share with you today. We've broken up the slides a little bit so that we can stop periodically to take any questions that might come up, but feel free to type your questions in the box at any point in time. We don't want you to lose the question waiting for us to take a break. Just a little bit about Disability Rights Michigan. We were formed through the same act that actually formed the DD Council. So we have that in common, as well as the DD Institute. And our mission is to advocate for protect legal rights of people with disabilities. So what that looks like on a regular basis at DRM is we provide information and referral services. We have our department that takes calls every single day, and they can provide information related to disabilities. And if we can't answer your question, there are a host of resources that we can refer you to. We also provide publications. We do trainings like this one. We monitor different facilities like nursing homes and psychiatric facilities. We do different investigations on abuse and neglect. We engage in systemic advocacy. And then on specific selected areas, we also do individual representation. Because we are in an unprecedented time, it's kind of nice to be able to rely on something that we do know, and that is special education law. That really actually hasn't changed. So we're going to spend a little time looking at that. And I always like to provide the citations because I think knowledge is power. And you can always look up the laws themselves. So the first is the Individuals with Disabilities Education Act, 20 USC 1400. You can Google that and it should pop right up for you. And a quick primer on the way federal law works. You have the federal laws that are passed by Congress, signed into law by the president, and then the agencies get to fill in the gaps because there's no way for Congress to anticipate every single situation. And the agencies are supposed to be more the experts, so they fill in all of the gaps. And that's what the regulations are at 34 CFR 300. In Michigan, we also have a special education set of rules called the Michigan Administrative Rules for Special Education. Very creative. We call it MARS for short because it just is too long of a name to say on a regular basis. And we provided that citation. And then also the Rehabilitation Act, Section 504 of that is in play as well. So you can take a look at that. You are welcome to look up these laws, but we also have a manual called the Advocates Manual. We just renamed it. And it's at drmich.org. It goes through all of these laws and actually and goes through some case law as well to explain how the different laws will apply to you as you develop an education program for your child. IDEA was created initially in 1975, and at that point, it was the Education for All Handicapped Children Act. It's gone through a whole host of reauthorizations. In 1990, the name was changed to IDEA, but the point of the law has always been to make sure children are in school. When it was initially passed, kids with disabilities were largely excluded from schools. So the point of IDEA is to improve results for children with disabilities inside the school setting. We want to make sure everyone has an equal chance to participate, to live independently. Right? That's what we want for all kids anyway. And kids with disabilities are no different and are what we expect of them. We also want to ensure access for all students. So under IDEA, eligible students have a right to an education. And in Michigan, only students with IEPs really do have that right to an education. They have a right to a free, appropriate education under both federal and state law. Part of IDEA is ensuring that all of those children who are eligible for special education services are found. So we call this the child find duty. The school district has to identify, locate, and evaluate all children who may have disabilities. And all really does mean all. If you have a child in a private school, this local school district has the responsibility to identify and evaluate them, okay? If someone has been suspended or expelled, just because they were not eligible for special education or not found eligible earlier, they could still be found eligible at this point in time if they have a disability that would qualify them for special education services. A school district needs to do evaluations even at that point. Under IDEA, education is defined and explained in a variety of manners. It's really important to understand academics are part of what IDEA is watching out for. We do want kids to be able to read and be able to do math, but such a big part of going to school is learning how to interact with other people, right? Interacting with peers, interacting with adults. This is how we become effective citizens in our society. So functional performance is only important, and it's part of what education is. So you can be doing just fine in your academic type classes, but have a really hard time engaging with peers or engaging with adults, and you could qualify for special education services in that way. In addition, if you already have an IEP, and maybe it is for something like a specific learning disability, but you start to have behavior type issues, you can get services to provide supports there so that you can build up those skills as well. So even if you're progressing from grade to grade, even if you're passing all those classes, you can still qualify for special education services. And then you can always get more supports as those become necessary.
Thanks, Erin, and thanks again, Tedra, and to the DD Council for putting on this webinar. I wanted to transition to talk a little bit about what's happening now. Erin has given us a great overview of what the special education laws are. Those laws are still in place. However, we have talked about a couple of different authorities, and I'd like to bring up a couple more because now that there is this public health crisis, it's not only departments of education at the state level, Department of Education at the federal level, those federal laws that Erin mentioned, the state laws, but also health departments, local and state, have a role to play in what the school environment looks like. However, I'd like to start off with the special education laws we just covered. Nothing about the pandemic or the public health crisis that's going on right now has changed those laws. There's been no waiver of any of the requirements of those laws, and so districts at the school level still must provide each eligible student with what we call a free, appropriate public education. That is known as FAPE, and it is the foundational requirement of special education services for each student who is eligible. districts also must still engage in those child find activities that Erin mentioned, whether a student is in the public school system or in a private school. And schools still must evaluate students to find whether they're eligible according to the timelines put forth in those state and federal regulations. 30 school days from a parent's informed consent is how long a school has. That's still the same. Every other requirement in IDEA and the MARS still applies to school districts, and that's important to remember. Now, you might be wondering, that's the current state of the law, but were those rights still in place last spring when everything shut down all of a sudden because COVID caught everyone unprepared and schools had to shut down? Students with disabilities never lost any rights, so what happens to all that lost school time at the end of last school year? Well, what's happened is that MDE has created something called Recovery Services for Foregone Learning. This is a way to address that lost time and any regression in skills that may be a result of a student's exclusion from the learning environment because of the school shutdown. There are some details that MDE has provided in a guidance document that we have a link to. We also will be sending a lot of the PDFs that we have included in this presentation to Tedra to be a part of the webinars posting online at the DD Institute. So if you have an interest in knowing more about how your student might be eligible for recovery services, that MDE guidance will be a good place to start. I also wanted to take a moment to explain that there's a different term called compensatory education, which might seem similar to recovery services. And in a lot of ways, they are similar, but in important ways, they're different. Compensatory education is what happens when a school district has failed to provide a student with something that was needed as according to the law. A student or their parent or guardian can file a complaint through an administrative process where the Michigan Department of Education will investigate and make a determination about whether there was any violations. There's another way to vindicate the rights of students with disabilities, and that's called due process. You can bring a due process complaint, and an administrative law judge could make a determination that the school, again, may have violated the student's rights, and that student is owed compensatory education. That's as a result of a school's violation, which is different from the school shutting down due to COVID. Important to note, we do have some guidance here from federal agencies that might refer to recovery services as compensatory education. That can be a little confusing, but know that here in Michigan, any services that are provided to students because of the shutdown are called recovery services. Now, last year, like I said, everyone was caught unaware. COVID came in and it was an immediate reaction to shut down the schools almost immediately. But in order to prepare for this school year, there's been a lot of work done at the state level to ensure that there is a safe return. I'm going to talk a little bit about how schools are required to plan to teach kids safely. This gets tied up with healthcare when you consider all the precautions that schools must take, especially when in person, to prevent any COVID outbreaks. To deal with these interests, the Michigan legislature passed a group of bills called the Return to Learn Act bills, and that's what we have up on the slide here, Public Act 149. It created a number of requirements for school districts. They had to create two things, one of which I'm going to talk here, another we're going to talk about a little bit later. The one that we're going to talk about here is called the Extended COVID-19 Learning Plan. We'll also talk a little bit about the Emergency Preparedness and Response Plan. That has to do with a lot of the public health safety measures that schools must take. district-wide in order to teach students. But we're going to talk here about the extended COVID learning plan. Now, this also has to be created in conjunction with a local health department, and it has to be improved by a district's intermediate school district. That's what we mean by ISD. An intermediate school district is usually a roughly county-sized entity that is an intermediary between Michigan Department of Education and your local school district. They help with a lot of administrative tasks. They act as an in-between for finances, and they also have a great deal of expertise, especially when it comes to special education, that is provided to each district. However, this extended COVID learning plan has to be approved by the ISD, and then it has to be put on the school's website. That document, that plan, will give you details about how the school is planning to provide instruction to students. Now, there's another issue that we're going to talk about a little later, again, that has to do with recent developments concerning Governor Whitmer's authority to issue executive orders. Late last week, October 2nd, the Michigan Supreme Court found that Governor Whitmer didn't have the authority to issue a number of executive orders that also deal with schools and how they operate. But we would like to note here that the local health departments for each school district at the county level and also at the state level have the authority to issue orders to control the COVID pandemic. And some of those orders may impact how the school environment looks, may impact how schools take preparations such as masks, mask wearing for students and for staff. Along with those local changes, there's also been guidance that's been provided by some of the federal oversight agencies. OSEP is the Office of Special Education Programs. They oversee the implementation of IDEA across all states. Each state is entrusted to implement IDEA's requirements faithfully. OSEP kind of monitors that, and they issue guidance like they did on September 28th to address the COVID pandemic and how the requirements of IDEA should be considered in that context. Likewise, OCR is the Office of Civil Rights, and they play a role in monitoring the enforcement of Section 504 of the Rehabilitation Act of 1973. Section 504, of course, protects students with disabilities from discrimination in schools and ensures them the right to effective communication with their teachers and peers, among other rights. That Q&A will provide more information on how those Section 504 rights are viewed in the context of COVID-19. At this point, we've gone over a lot of different laws and regulations, some guidance, both federal and state. If you have any questions at this time, we'd be happy to answer them. I think we can also look in the chat and see if we have anything. If we don't have any questions, Tedra, is there anything that you've got for questions?
There's nothing in Q&A at this time.
Okay.
Thank you. So now that we've laid the foundation of IDEA and talked about how things have changed a little bit with COVID, we have some OSEP guidance, some OCR guidance. Move on and look at the IEP just a little bit. As Mitch said, there were not any waivers under IDEA, so everything is still in play. So you want to look at the IEP to see how is that going to provide the educational plan going forward. If you are involved in special education, you know what an IEP is, right? An individualized education. This is what says what's going on with your child. What services are they being provided? What sorts of related supports there are, what accommodations, what modifications are being made as well. The IEP must provide a free, appropriate public education. talk about all the time, a FAPE, and it must be in the least restrictive environment. Typically what we're saying is you start in general education, you get some maybe push-in services, or maybe you just get some assignments modified. And then maybe you do some time in resource room if that's not enough. Maybe you go and see the social worker rather than just getting some push-in social work time. Then if that's not enough, maybe you need to have your services in the resource room itself. Or maybe you need to spend some time in a categorical classroom. Or then maybe you need to move into a center-based type program. And then at the very end, we're looking at things like Homebound and Hospitalized. So that's the least restrictive environment. It's a continuum. Your LRE is going to look a little bit different potentially, just because, for instance, your general education peers might only be able to be interacted with via Zoom. And that might not be something you're used to, and that might not even be something totally accessible to you. So that's something to keep in mind. Additionally, your school district can choose to go in person right now, can choose to go all virtual, can choose to do a hybrid. So the LRE might look a little bit different than you're used to, just because of those physical differences going on as we deal with the pandemic. And IDEA actually goes through specifically who has to be at those IEP meetings, developing the IEP, the steps you have to go through, and then what the pieces the IEP actually has to entail. And like I said, it has to provide a FAPE. So let's talk about what a FAPE is. It's free. Free means at no cost to the parent. And that even means, for instance, if an evaluation needs to be done to determine eligibility, for instance, maybe there's a concern about ADHD, but a child doesn't have an ADHD diagnosis. There's maybe the suspect of one, or the suspicion that there is one, I should say. So if the parent isn't able to get that diagnosis from a physician, the school can help get that facilitated. So that way that the parent is actually not paying for something out of pocket that's needed to get the child eligible for special education. Now, if you already have the diagnosis, great, just provide it to the school. But if it's not something there already, it should not cost the parent money to get it done. Appropriate was clarified recently through the Supreme Court Andrew F. case. At that point, the Supreme Court explained that appropriate means tailored to the unique needs of a particular child. The IEP has to be reasonably calculated to enable a child to make progress, appropriate in light of the child's circumstances. We're talking about the child's circumstances, not the overall environment, not the climate. COVID is not the child's circumstances. We're talking about the child's abilities, the child's disability. You're looking at data specific to what the child can and can't do. Where does the child need more support? We're not looking at the climate outside. And this is always data-based. We want to make sure when we're creating an IEP that the goals are appropriately ambitious in light of the child's circumstances. We don't want to just be basing our ideas on stereotypes or just, well, we think the child can do this, or we think they can't really do this yet. We want good, and that's based on evaluations. And at this point, good data is also based on observations from parents. You had your child all last spring, and you were there seeing how they were doing. Where were they struggling? Where were they excelling? And that's information that you can provide to your IEP team as you review your IEPs this fall. And you should be doing that, right? You have to have an IEP in place at the beginning of every school year. That doesn't always mean you have to have a new IEP. Your IEP could have still been good from last year, but because of everything that's happened since last March, it's entirely possible that your child may need more supports than they had before. So you need to have an IEP meeting to discuss that. And you might need to have new evaluations to make sure that you're basing your IEP decisions on good data. So we talked about FAPE a little bit and what the definition is based on the Supreme Court. So let's look at, again, FAPE is individualized. It should not be X disability gets X services. That's not individualized. It needs to be according to the specific student's need. Everything ties back to need, which is why good data is so important. And your accommodations and services might look a little bit different based on the fact that we are providing services in a virtual or even a hybrid setting. When you're in person, for instance, you don't need a computer screen necessarily to interact with your teacher. Well, depending on your disability, you might need more accommodations or more assistive technology in order to be able to access your services. You might need a headset, for instance. You might need a larger screen, or you might not be able to even access your services via the computer. So that's all something to keep in mind. However, FAPE does not mean that you get to pick the curriculum for your child. It doesn't mean that you get to choose the personnel who provide the services. Those are both district decisions. And FAPE is not convenience. Having kids at home all last spring, and even some kids are still getting virtual instruction right now, is very difficult. And if your child cannot access their educational services that way, then that is absolutely something to address with your IEP team, okay? Your child needs to be able to access services, but it can't just be a parental convenience issue in terms of, well, I need to go to work, therefore my kid needs to be at school. That's not what this is about. This is about building the program that gives your child what they need to make progress appropriate in light of their circumstances.
Okay, and so that's an overview of the IEP process. As Erin mentioned, the IEP is a document that provides a student with disabilities the educational plan to provide them a FAPE. And as I talked about before, the laws haven't changed, but there have been changing conditions. And in response to that, state and federal stakeholders have provided guidance in how to handle the appropriate provision of special education to students. In Michigan, the Department of Education has strongly recommended that the IEPs that are being developed now be developed for a brick and mortar setting, as if a student were to go back and be in person instructed by teachers in school classrooms. However, MDE has also strongly suggested that in addition to that base default understanding that an IEP team includes something called a contingency learning plan. This has also been referred to as a pivot plan, because the idea is that if something happens that a student isn't going to be able to receive instruction in an in-person setting, then this is the plan that will take over. Now, it is an extension of the IEP. It is still viewed as part of the IEP's implementation, which is important when it comes to upholding a student's rights that are afforded under IDEA, such as the provision of FAPE. A contingency learning plan still must provide a FAPE. And these contingency learning plans, like IEPs, must also have meaningful participation from parents. Although this is not a part of the law, this is something that has been suggested strongly by MDE, also taken from suggestions by OSEP as well. These contingency learning plans, in a way, are like the extended COVID learning plans for districts. The districts use these extended COVID learning plans to adapt to the circumstances on an ongoing basis. Contingency learning plans also are plans that are forward-thinking. They're meant to provide the free, appropriate public education that a student requires in different conditions. And those different conditions are different for each student. It could be that your contingency learning plan is triggered when a district has a COVID outbreak and they have to go virtual, or the entire state goes virtual. Could be that the student has specific medical needs that put them in a compromised, where they have a compromised immune system and they have to be at home. These kinds of events that require the school to pivot to the contingency learning plan are included in the IEP, and it's something that the school and the parent should be working on together. It's possible that when you develop the IEP, the event has already occurred. And so you develop the IEP with the assumption that the student is in person in the classroom, when that may not be the case. But it's important to know that both of them require FAPE. Now, because this is FAPE, but likely at home in the contingency learning plan, it's important to know that supports and services may not look like what a student with a disability is used to in their typical IEP. OT, PT, a lot of services that would probably be best provided in person there may not be that option. It may have to be a telemedicine option, and it may require additional supports and services such as assistive technology. And that may be something that needs an evaluation. You may need an AT evaluation to know exactly what technology will help the student access the supports that they need for a free, appropriate public education. And that's something that you can request. And like all our usual advocacy tips in times that are not during a public health pandemic, communication with the school district in writing is the best way to communicate a need for an evaluation like an AT evaluation. In addition, these are unprecedented times. Lots of parents are having to manage their children's schoolwork in a way that is new and different. Training for parents is something that a school can offer. It is something that can be included in an IEP, and it's something that we suggest parents think about. It may be beneficial. It's also important to know that there is no transfer of responsibility under the laws to a parent simply because they're trained by the school. The school is still responsible for providing your student with a free, appropriate public education. It just may mean that they offer the parent supports as well for that to happen. Last, I wanted to talk a little bit about contingency learning plans and what Erin had mentioned earlier when she was discussing the spectrum of placements in reference to the least restrictive environment. At the very end, she had mentioned homebound and hospitalized. That is a category where students are receiving services because they are at home or they are in the hospital. The category homebound and hospitalized typically requires a doctor's note. And many times students will receive a minimum of services if that is their placement. That minimum of services is 2 non-consecutive hours per week and related services. Occasionally, school districts make any plan for a student who is going to be at home, one that is very similar to what used to be the homebound hospitalized placement and that minimum standard. Now, it's not always sufficient to provide a student a free, appropriate public education, and that's what they require. If a school is putting a student on that minimum of services and it doesn't require a FAPE, that may be a violation of the law. That's something that to keep in mind when these contingency learning plans are being created. Again, we've talked a lot about all of the federal laws, all of the state and federal guidance that has come out to supplement the understanding of those laws during this pandemic. And now we've gone through the IEP process and an overview of contingency learning plans. These IEPs and contingency learning plans are foundational to a student's educational program and their rights. If we have any questions about all of this overview right now, we're happy to take them. Otherwise, we can move into dispute resolution. Okay.
No
Mitchell?
questions in Q&A at this time.
Mitchell, we have a question in the chat. Can you give us examples of these?
Of a contingency learning plan? Is that the?
It just came up, so I'm gonna say,
That would be my
I'm
assumption.
gonna ask Sandy, can you clarify what you would like examples of exactly from that slide? Yes, of the contingency learning plans, Mitchell.
Okay. MDE's strong suggestion was that IEPs be created with that default setting in mind, the actual classroom. A lot of students don't have that option right now. And so contingency learning plans are what the school can offer that will still provide a student with a free, appropriate public education. It may be that a student is typically in the classroom and they get OT and PT in person. If that's not an option because they're at home and the school can't send an OT or a PT to their home, then it may be that the contingency learning plan has provision for telemedicine for PT and OT. That's just one example of a service changing because of the setting. And the way that the protections would still apply for a student is that the IEP is still in place and the contingency learning plan is a part of that IEP. So they both are the school's provision of FAPE, their offer of FAPE. But it just looks a little different because of the public health circumstances. I don't know if you've got any other examples, Erin, that might help illustrate the difference between your typical IEP and the contingency learning plan.
Yeah, I could see, for instance, in an IEP, typically you see resource room time spelled out in an amount of minutes per day or per week. You could see categorical classroom time spelled out as well. Your minutes might look a little bit different in your contingency learning plan because, for instance, we don't want kids sitting at a computer for 7 hours a day. So the minutes could change in that. I think that was a good example you gave, Mitchell, of the services going virtual. Now, it's also possible that some of the services might not be able to be provided. This might not be spelled out in the contingency learning plan, but if there's something that really cannot be provided virtually, it could say something about how the school is just going to plan on providing the services later on that were missed or comes up and comes back. I know the link we sent or that we have from MDE about contingency learning plans goes into that a little bit more. But I haven't seen a specific like template yet or anything like that.
Yeah, one other thing that may be different is that the numbers might change, the method of delivery may change, and the service provider may change. It may be that your student's preferred service provider, they may have a real connection with their speech language pathologist at school, but that person may not be able to use a telemedicine model. And so you may end up with a different service provider because the telemedicine requires that someone else deliver those services. And that's something that is another change that you might see in an IEP to a contingency learning plan. So I hope that's helpful.
And the idea is that the parents are actively participating in the process of making the contingency learning plan. So that way you understand what the plan in writing actually would look like in practice. The idea is that there's a very smooth transition. There's not a huge hiccup in, okay, well, now we're going virtual. What does this mean? We have to figure it all out. Nope, the plan lays how those services will be provided, when those classes will occur, how are your like homework packets or activity packets or just, you know, your logins, how are those going to be provided to you each day? What is that going to look like for the student? Especially it's something like shorter assignments or extended assignment time. Maybe that will change a little bit. Maybe the kid will need more time. Maybe they'll need a little bit less time because they're not in the classroom all day long. Again, it really depends on what the child needs as to how specific those or what specifics will be in the contingency learning plan.
Erin, we have one question from Q&A.
Okay.
Sandy writes, is there any help for kids who don't have internet access and it is difficult for them to get to the location where they can get access for virtual learning or services?
Yeah, that's a great question. Yes, if your IEP, well, okay, let's look at it first. If your district is doing virtual only, or if you and your district have decided your child is doing virtual only, in order for that child to access their services, if they need a more stable connection, the district needs to help with that. They need to help make that happen. I know maybe more specifically, if you look at like different providers, some of them had like jetpacks or whatever they were providing to kids at no cost. I know some school districts were working with different providers to make sure that the students were getting those tools that they needed, because that's a huge issue. If they can't access their services because they don't have the internet, which is, there are huge chunks of our state that access is incredibly limited, not just for students, but for teachers as well. That's something that the district needs to figure out. That's a huge problem. And that can be solved a lot of different ways. It could also look like having maybe providing transportation if they have internet access at a specific place, but you can't access that because you don't have the transportation. That's something the district could help out with as well. There are lots of different ways to solve the same problem. So we encourage you to reach out, definitely outline everything in writing. And this is a great segue into resolving issues, where we're going to next. Send an email saying, here's what's going on. Here's the problem. How can we get my child access to their services?
And I just wanted to add that in addition to the basic internet access, there may be other issues that could complicate a student's access to the educational content, which can be something that would be the subject of an assistive technology evaluation. If someone has a visual impairment, making sure that they have the JAWS software or something equivalent that addresses their needs can be important as well.
Good. Okay, so we'll head into resolving issues unless there are any other questions. Okay. So you're bound to run into problems, for instance, not being able to access any of your services because of internet issues. First, we always encourage parents to engage in informal problem solving. Remember, the district still has the responsibility to provide your child a free, appropriate public education, whether you're in person or a hybrid of those. If something is not working, communicate with the district right then and there, and do so in writing. The reason we say do it in writing is because that way it's clear. Everyone can refer back to the writing. There's a chance to correct misunderstandings and then write them out clearer. And we usually suggest doing email because it's the quickest way. You have the writing, you can refer back to it. And that way later on, if problem solving doesn't work, then you have a written record of what has happened. Communicating with the district is extremely, extremely important because many of the issues that we see arise are because of misunderstandings or just a miscommunication about what is going on, how it's going on. So if you bring up your concerns to the district, they can then clarify what's going on, and typically you can fix the problems that way. If the district responds to you by phone, that's fine. Talk on the phone. If they talk to you in person, that's fine as well. But follow up in an email. Thank the district for talking to you and spending time explaining things to you. Tell them what you understand based on the conversation. And that gives the district then an opportunity to correct anything, again, was miscommunicated, that is misunderstood. That way everyone is on the same page going forward. And that way, again, you can refer back and say, what did we talk about? When did we talk about that? Okay, it's only been like a week. Because sometimes we don't remember how, especially right now, I feel like it's really hard to keep track of time. You have that timestamp, you can go back and say, okay, well, this was only a week ago. They can have a little bit more time, or it's been 3 weeks now, nothing's happening. Or it's been 2 months, again, nothing's happening. Or we talked about having a behavior plan in place and having daily communication home. And I haven't seen any of that. Remember, we talked about this. You can refer back to that time. Whenever you are discussing problems, always tie the problem back to your student's need. Remember, the IEP looks at data, and it looks at where your child has challenges, where they're excelling, and you tie your goals and everything back to what your child needs in order to make progress. Be as specific as possible when you're talking about those needs. And I gave a few examples here. It could be something related to reading class and how long your child can sit and pay attention in reading class. It could be something like your student is just having a really hard time getting up in the morning, and they're saying things that are making you concerned about the potential of depression. Or maybe they just need some more motivation and you need help with that. It's okay to ask the school for ideas. Professionals, they're educational professionals. They may have suggestions for how you can support your child. And it could be something on their end that they can implement as well. It could be a math related issue. Maybe they can do some math in the multiplication, but they're really struggling with something with word problems. So you can fix your accommodations and your modifications based on, again, where is struggling. Because we're doing so many things virtual, your student, again, might have more issues paying attention on the computer, or maybe there's issues with vision or with posture that make sitting in front of a computer screen very difficult. And those could be easily fixed by maybe a larger computer screen, maybe fewer number of minutes on the computer each day. Maybe just having a headset can help with some of those issues. We encourage using strategies. You can always request evaluations if you feel that your child is not making progress or the progress they should be making. And that doesn't mean you have to go through a full battery of comprehensive educational evaluations. If there are speech and language struggles, you can have only a speech and language evaluation. If there are behavior type issues, you can request a functional behavior assessment be done, so that way a behavior intervention plan can be created. Now, coming back from being gone all last spring, having that long summer, students have experienced just a boatload of sometimes very tragic events, and sometimes it's just a startling experience to have to say goodbye to your teachers and friends one day and then not get to come back for months on end. And how kids react to that is going to be varied. So it's entirely possible that your child has a traumatic experience, and that's going to affect them in school. And there are evaluations that can be done to gauge that and to figure out what kind of supports the child needs. So that's something you can request as well. And it could also be the trauma could affect other areas. It's not your part, but it could also be like in terms of they don't want to do time or they don't want to do any math time. It could be related to the traumatic events they've recently experienced. And let me emphasize again, every child is going to react to these events differently. So just because one child is doing totally fine, another child could have experienced the exact same events, could affect them very, very differently. We encourage you to review and revise the IEP that your student has. Again, coming back from being gone for months, the IEP might not be as helpful as it could have been before. This is why we review them at the beginning of the year. And you can again ask for, if you need new evaluations, you can request more supports for your child based on those evaluations, based on the data that you as a parent have collected. You've written down how long it takes them to get their math problems done, or how long it takes them to focus to get down to work in science, for instance. You can then reconvene for lack of progress. You can always ask for an IEP meeting. If the district sees that your child is not making appropriate progress, then they should be calling an IEP meeting as well. But if they don't, you can ask for one. And at those IEP meetings, you should be discussing what you think your child needs, and the school can agree with you or disagree with you. But the information from those conversations needs to end up on that last page, that notice page that talks about what discussed and why you decided not to go that route. That's very helpful later on. It's part of the prior written notice. Later on, if you have to formal problem solving, you can go back and say, see, we talked about doing in person because my student really struggled, and they know they couldn't do it because they weren't providing in person to any students at all. Not because the state wouldn't allow them to, but they just decided no student is getting in person. That can be helpful later on for you. If you come to an agreement with the district over email or over a Zoom meeting or something that your student needs a certain accommodation added, you can just have an IEP amendment. It's okay to do that with small things. If you agree something needs to be tweaked, get it in an IEP amendment, and then you don't have to have a full meeting. But you can also have a meeting over Zoom. You don't have to have in-person meetings on the phone if you are not able to make it. And that might be the safest thing to do right now, is to still meet remotely. And then you can go through all of these steps again. This isn't a one and done. The school district has to evaluate every 3 years unless everyone agrees to waive those evaluations, but you can always evaluate more than that. There are some more specific parameters depending on the specific test you choose to use. Not necessarily you, the school district personnel choose to use, I should say. Some of those tests cannot be repeated more than one time a year, but there are also different psychological evaluations that can be done, or different academic type assessments. So just because you've already done one doesn't mean you can't do another one. Another piece to look at it's part of the IEP, but it's often quickly run through, is extended school year services. This is predictive, as in the IEP team looks at how the child did before over long periods of time when they were not in school, and sees how much either they regressed without picking it up quickly, or you're looking at the specific goals. Maybe they're on the cusp of learning something, and maybe the student would really benefit from having additional services either over the summer or even winter break and fall break, if you have fall break, or spring break, I should say. These are good times to collect the data to then look at during the summertime. But also this is a time when extra services and supports could be offered to your student to make sure they're not missing out on those services when they could be extra helpful to keep your child on pace to where they should be. And the specific criteria that the school district would have to look at is actually located in MARS and its school year services.
Okay, I wanted to talk a minute about something that is a different right that students with disabilities have who are eligible for special education. That's called an independent educational evaluation. Now, you may be going through all the steps that we have discussed. Erin's mentioned communicating with the school in writing, being specific about your concerns and tying those concerns back to your students' needs. You may present a convincing argument that your student needs a functional behavior assessment, something that will look at their behaviors, try and understand the underlying motivations so that the school can create proper behavior supports that will help the student succeed educationally and functionally, academically and functionally, I should say. But if the school does perform that FBA or any other evaluation, it could be an AT evaluation, could be for speech and language, it could be for OT or PT, and you disagree with the results of that evaluation, you have a right to disagree with it and request an independent educational evaluation. Now, independent means that it's performed by someone outside of the school. This can be someone of your choosing. Now, the school can also put some limits on the services that are provided in this independent evaluation. And by and large, they have two options in terms of response. They can respond with a yes, and the independent educational evaluation can go forward, and you can get another person's take on this particular issue, whether it's OT or PT or AT or behavior. And then you can use that information as a means of contrasting with what the school presented in their evaluation results. Taking both of those, you might end up with different services. You might end up coming to a different agreement with the school, and that's one avenue. The other avenue is that the school may file for due process to defend the evaluation that you disagreed with at the start. Now, that transitions us away from informal problem solving to formal problem solving. And yes,
Mitchell,
We do have a,
before we move on to formal problem solving, I have two questions.
yes, go ahead.
One, does the independent evaluation have to be paid for? Does the school have to pay for it, or do parents have to pay for it themselves if it's approved?
Yeah, that's a great
And
question.
two,
And
where would parents find the person that would perform the independent evaluation?
I'll take the first question. It's a great question. The school does have to pay for the independent educational evaluation. Some of what I mentioned in terms of restrictions or limits are that the cost can't be excessive. The school doesn't have to agree to an independent educational evaluation that is exorbitant. So that's one of the limits on it, but typically that independent educational evaluation is part of IDEA and the rights the student has under IDEA to a free, appropriate public education. And free is still free. So the school district is responsible for that cost. The second question, could you refresh me?
there's a question in Q&A.
Where would the parents find the evaluators? Is
Okay,
there an
that's-
association, or the school is supposed to keep a list, or?
That can be variable. It depends on the subject area. Doing Google searches informally can sometimes lead you to different associations of professionals that may lead you to different local resources. It depends. But the school, and Aaron, you may want to check me. I don't think they have any independent responsibility to provide you with resources about that subject area and who might be available.
So what the school has to, when they respond to your request for an, am I unmuted? Yeah,
Yes.
sorry. The school has to respond to your request for an IEE, publicly funded IEE with certain criteria. And it can be about the cost that they would allow. It can be about the, sometimes they say distance because they don't want somebody coming in from like 3 hours away. And that might be reasonable if you live in Detroit. It might not be as reasonable if you live the upper part of Lower Peninsula or even in the UP. And they typically do provide you a list of providers. I don't remember if they have to. I'll look that part up. And the bill talks about what the district's response must include. Sometimes the district doesn't realize they have to include all this information. But they typically provide you with a list. Usually those lists are outdated. What we would recommend is you go through their list and see if any of those providers are willing to do the evaluation for the amount of money that the school district is allowing. And if their own list doesn't actually meet up with the amount that's being provided, that's strong evidence of you needing a little bit more money for your evaluation. And there are sample letters in our manual about how to then request a little bit more money. I'm not talking about $10,000, but something like I've seen, $1,500 to $2,500 for different evaluations done. If they're allowing $800, that's probably not going to get you what you need. If you have an outside service provider, they might have suggestions for other people who could do evaluations. Sometimes parent groups have really good suggestions. Trying to think.
Community mental health.
Community mental health, yeah, exactly. Might have suggestions about where you can get those evaluators from. Some areas there's a ton of evaluators and some there aren't, so it can be a little bit more challenging. You can also look at the national organizations. Typically they then have a state organization, like the PTs, the OTs, the psychologists, school psychologists have a state organization, and you can look up people that way. You would want to vet those and make sure their evaluation will be comparable to the school's evaluation. For instance, if you're looking at something like a psychological evaluation or a social work evaluation or an FBA, you want that evaluator to do an in-person observation as well, because that's usually part of what the evaluation entails.
We have a question from Q&A as well. Are you ready for that?
Yeah, that's fine.
The question is, what services are available for parents who they themselves have learning delays and struggle to understand services that are available, laws, guidelines, and such for their child's services?
That is a really great question. I don't know of resources off the top, but that could absolutely be part of the parent training piece. If you're having a hard time understanding what the school's talking about, your first source is always asking them, what are you talking about? Please explain to me all of these things that these evaluations, these services, how does this tie in? And we do have some resources at the end that can give a little bit more background on that information. But that's something I'll definitely look into, and I can give Tedra if I find any other good, very accessible resources, because sometimes they're not very helpful in terms of how complicated they can be. Some of the resources we have at the end are very good, condensed, digestible versions. And I'm not sure about the accessibility in terms of like using a screen reader or something like that. But definitely tap into the parent training. That your school district or even your ISD might have some really good resources for parents who are struggling to understand this. They might have peer mentor supports through the district or the ISD as well.
I think Michigan Alliance for Families
Yes.
also provides some informal advocacy help to parents and families in these situations as well. So Michigan Alliance for Families might be another resource.
Yep. Okay. Mitch, do you want to go back to, I think you're talking about due process hearings?
Yeah, we had first started talking about the IEEs, independent educational evaluations, and those parameters that we talked about set some limits, and it sometimes leads school districts to instead defend their original evaluation. And the way that they do that is by filing for due process. Due process is a series of procedures that results in a trial-like hearing before an administrative law judge who makes a determination about whether the school followed the law. It is almost like a trial. It is very formal. If you find that you are going to be in a due process proceeding, we highly recommend that you retain an attorney. There is a 2-year statute of limitations for a due process complaint. And that means if you are filing a complaint on your student's behalf for what you feel has been a violation, you can go back 2 years in time to capture any violations in that time. Now, I want to go back for a minute to revisit some of the informal processes and procedures that we talk about for communicating with schools and things, and just give you a little context about why that's important for the more formal problem-solving procedures like due process. The administrative law judge is what we call a third-party neutral, someone who's supposed to be able to look at facts and arguments and weigh them and come to a determination. And when the judge, the administrative law judge, is given emails and given educational records and given all of these other written documents, it makes the story clearer than sometimes a lot of he said, she said, which might be what happens if all of the advocacy that you do is over the phone or in person. Being able to follow the different changes in the educational program through what Erin had talked about before, the prior written notice, where a parent can suggest different avenues or different supports for a student, and then the school has to respond in that prior written notice and say, yes, we agree that this is appropriate, we're going to incorporate it, or no, this is not going to be incorporated, and here's our reason why. Those things become very important if you do end up in this formal setting, which is also why we suggest reducing things to writing, if at all possible. Email may not be the most convenient means for you to communicate with your school district, but we highly suggest it. Now, the due process isn't the only procedure that's formal that will allow you to get a determination about whether a school violated your students' educational rights. The other avenue is a state administrative complaint. Now, this is less formal. You don't need to have an attorney to engage in this form of issue resolution. In this administrative complaint process, the Michigan Department of Education, you give a complaint to the Michigan Department of Education along with your local school district or the school district that's serving your student, and you provide the details of the issue that you believe is a problem, where you think that your students' rights may have been violated, and MDE assigns an investigator. That investigator has 60 days to look through all the records, interview people at the school district, interview you, and come to a determination. Now, these administrative complaints cover issues of FAPE, and FAPE is required whether it's through the IEP or the contingency learning plan. So if you have an issue with how the contingency learning plan is being delivered, that can also be the subject of an administrative complaint. Same for due process. And in this case, instead of having 2 years to look back, an administrative complaint only has 1 year. So when you file that complaint, it can only be for things that have happened in the past year. The day that you file it, that's the day that they look back to in the previous year. Now, there are more resources that we have, and that's going to be coming up in a second. I also wanted to one more time mention that if you're thinking about filing a complaint, whether it's a state administrative complaint or a due process complaint, our advocates manual on our website at drmich.org provides a whole host of information that gives you a lot more context about the laws and regulations that we mentioned at the very beginning. And it's available, it's a free resource. It will be included in the posting of this webinar online and later. But before we get into further resources, if there are any more questions, I think that there's nothing new in the Q&A, but if there's anyone else who has a question, happy to answer now.
Nothing in the Q&A at this time.
Okay, so let's take a look at some resources. And one thing I wanted to mention really quickly when we were talking about IEEs at public expense, you can always bring in an outside evaluation that you had from a school or a previous provider. And that's information that you can bring into an IEP meeting and talk about. Any data you have, you can bring in. That might be considered an IEE, but it's not an IEE at public expense. And you could always pay for your own evaluation to be done at the same time. But when we were talking about IEEs here, we're talking about at public expense. And you can get one of those each time you have an evaluation that the district does that you disagree with. So looking at these resources, I went through and pulled out some resources related more specifically to COVID. The Office of Special Education Programs did 3 webinars this summer about continuity of learning during COVID-19. And this first resource is their homepage all about continuity of learning, excuse me. So there's a ton of information on that, and I pulled from that these resources because I thought they were the most helpful or most appropriate at this point. But I wanted you to have as much as possible. The second resource up here is actually a PDF of all of the resources provided by the related service organizations, related service provider organizations. So if you just want information about occupational therapy, that's chunked out. If you just want information about speech and language provision, that's chunked out as well. So you can look at it that way. And then the next resource is the actual webinar itself, if you want to watch the whole thing on related service providers during COVID. The physical therapy piece I thought was especially helpful, not just for physical therapy, but for telemedicine or virtual provision of any services. It has some good reminders about what to think about and how to engage in that, even if we do go virtual, because you know we've got a long winter ahead of us, and who knows what's going to happen at this point. This next resource looks at research-based interventions, and it's very digestible. Oftentimes I find these resources to be very hard to understand, very lengthy, and I don't typically have time to read a 25-page paper about research-based resources, but this is 5 pages. It's condensed, it's digestible, it's pretty easy to read through, and just talks about what works and what doesn't work for kids with disabilities, and how to reduce those learning gaps. And then the next one gives specific examples of what IEPs can look like, specific examples of resources, vocabulary, for instance, that might be used. Like it talks about synchronous versus asynchronous, which you hear all the time now, and I don't think I ever heard prior to all of this COVID craziness. So it's helpful of just understanding what people mean when they're speaking at this point in time. And again, if that's not helpful, ask the individual themselves when they're speaking, if you don't understand what they're talking about or how that looks for your child. And then we have the National Center on Deafblindness, and those services will look very different virtual as compared to in person. The next resource is the Early Childhood Technical Assistance Center. This is for the littlest of our kiddos. Have some really good information about how to deliver services virtually when you have a small child, and how to engage with a child during the time of COVID, and even talking about what COVID is and just dealing with the different concerns a small child might have and how those might evince themselves as compared to older kids. So the National Association of State Directors of Special Education put out this next, and it looks at the least restrictive environment based on a student's IEP. There are, I think, 2 different students they go through, and they talk about what services the child needs and how those services look depending on if the school district is providing services in person, brick and mortar, whether it's virtual or whether it's a hybrid, and how the LRE might look a little bit different. And then this last resource I've included discusses assessments in a way that I think is very easy to understand. It talks about informal versus formal assessments, and different interventions that can be used and what all of those mean. There is a part of the website that's trying to sell you something. You can ignore that piece, but it's got a lot of really good background information about assessments, what they measure. So that way, when the school is talking to you, you understand what these assessments are. And also you could suggest assessments. That doesn't mean the district has to listen to your suggestions. But if you have read about assessments and you think this other assessment might measure your child's ability a little bit better, especially if you have a child who's nonverbal, for instance, suggest it. Or the school might come up with another one that's comparable, but also takes into account your student and their needs.
Excuse me. We wanted to wrap up with a slide about some recent developments in the law that address some of the governor's efforts to combat COVID-19. The Michigan Supreme Court recently found that the law that Governor Whitmer was using to issue executive orders was unconstitutional. That happened just last Friday. There is some idea of when that will take place, but it's not certain. The idea is typically there's a 21-day time period where a court's order isn't in effect, but we're not really certain when this order will go into effect. But when it does, Governor Whitmer's executive orders after April 30th are going to be invalidated. And many of those executive orders touch on issues that impact the school environment, including a mask mandate. Now, this is complicated, and I'm going to walk through a little bit of the legislative efforts that were taken to ensure that schools were giving instructions to students safely prior to the start of this school year. There were executive orders that were issued by Governor Whitmer that set up a council to issue what was called the Return to School Roadmap, which gave schools an understanding of what the state was expecting in terms of requirements and strong suggestions concerning safety and school instruction. Along with that, there was an executive order issued that required that schools create an emergency preparedness and response plan. This was something to be developed in conjunction with local health officials and was meant to provide the entire school district with guidelines for how to be safe and teach students during the pandemic. Those were created and they had to be approved by ISDs, and that happened August 15th. Just after that, the return to learn bills that we talked about earlier were signed into law, and schools also had to create their extended COVID learning plans. And these COVID learning plans also incorporated some of the emergency preparedness and response plans. Some didn't. But the takeaway is that many of the school district plans in place right now will likely still require masks because they were created during a time when these executive orders were authoritative. But those guidelines about masks and things can change. This is a situation that is continuing to evolve. Now that's what schools can do. In addition to what schools can do based on the law and the executive orders, which are no longer law, very likely soon, local health departments also have authority to issue orders in a pandemic. And that applies to both county level health departments and the state level health department. As recently as yesterday, the Michigan Department of Health and Human Services issued 3 separate orders concerning the pandemic, many of which overlapped with some of the executive orders that Governor Whitmer had issued that are going to be invalidated soon. So this is something where the law and requirements for schools is in a little bit of flux. And so what we are hoping is that there will be clarity soon. We do hope that if you or your student experience any change in your IEP or your continuing continuity of learning plan, that you let us know. We're very interested to see how this is affecting students on the ground. These are some very high level ideas, and our concern is always for the students in the classroom or not in the classroom. However they come to us, we're hoping to help. So knowing about any of these concerns in the community is very important for us. And with that in mind, I just wanted to move to where you can contact us. We have an office in Lansing. We also have an office in Marquette, and the contact information for the Lansing office and the Marquette office is up here. That, as well as our website, www.drmish.org. I believe that there's an online box that you can use to submit your concerns that way as well, if that's easier. And if there are any other final questions or concerns, we're happy to respond. And again, thank you, Tedra, thank you to the DD Council. We really appreciate this opportunity to share this information with everyone.
There are no questions in Q&A at this time.
Well,
Okay.
I would. Oh, go ahead, Erin.
I was just going to say thank you so much for your time and all of the thoughtful questions that were asked.
Yes.
I would just like to say thank you to Erin and Mitch for sharing this really valuable information with us today, and for all of you for spending your time with the council this afternoon. Please join us again next Thursday at 11 o'clock. Our speaker will be from 211 Michigan, talking about how people can access services using 211, which is really underutilized, especially in the disability community, and also how as an organization you can register for people to find you as to find your services and support using 211. So that is what's on the docket for us next week, and we hope that you'll join us again. Thanks, everyone.
Thank you.
Thank you.